Judgment in the HS2 appeals.
Lord Reid will give the judgment.
In this case, the appellants have challenged the Secretary of State's decision to introduce in Parliament a bill to authorise the development of HS2, the proposed high-speed railway between London and Birmingham and the north of England, on the ground that it is contrary to EU environmental law. The appellants include a number of local authorities along the proposed route, a number of action groups and residents' associations opposed to HS2, and an organisation promoting the integration of HS2 and Heathrow Airport. They rely on two arguments. First, it's argued that the command paper, which preceded the bill, in which the government set out its proposals for HS2, fell within the scope of the EU Strategic Environmental Assessment Directive, and that a strategic environmental assessment should therefore have been carried out. The directive applies to plans or programmes which set a framework for future decisions whether to grant development consent for projects. It's argued that the command paper set the framework for the decision whether to grant consent for HS2. Secondly, it's argued that the legislative procedure in Parliament does not meet the requirements of the EU Environmental Impact Assessment Directive. The European Court of Justice has interpreted that directive as imposing a number of requirements. These include a requirement that the legislature must have available to it the information required by the directive, and a requirement that national courts must be able to verify that the requirements of a directive have been satisfied, taking account of the entire legislative process, including the preparatory documents and the parliamentary debates. In two cases before the Court of Justice, the Advocate General has interpreted the directive as also requiring that the national court must decide whether the legislative process has allowed sufficient preparation and discussion time for the legislature to be able properly to examine and debate the environmental effects of the project. On that basis, the appellants argue that this court should assess the likely adequacy of the parliamentary procedures and debates concerning HS2, including the extent to which members are likely to consider, understand, and apply an independent mind to the environmental issues. It is argued that members of Parliament will not apply an independent mind to the issues, since votes in the House of Commons are likely to be subject to the whip, and members of the government can be expected to vote in accordance with their collective responsibility. That the time allowed for debate will be too short to enable members to give adequate consideration to the environmental issues, and that most members are unlikely to attend the debate in any event. In these circumstances, it is argued, the parliamentary procedure will fail to comply with the requirements of the directive. These arguments were rejected by the High Court and by a majority of the Court of Appeal. The further appeal to this court is unanimously dismissed. In relation to the argument concerning the need for the command paper to have been preceded by a strategic environmental assessment, the reasoning of the majority of the court is set out in a judgment given by Lord Carnwath. Lady Hale and Lord Sumption add separate concurring judgments. The appellant's argument is rejected on the basis that the command paper fell outside the scope of a directive. It did not set a framework for the decision whether to grant consent for the HS2 project, since it did not constrain Parliament's decision in any way. It simply set out a proposal to be brought forward in a bill, leaving entirely up to Parliament the decision that it might take in relation to the bill. In relation to the argument concerning parliamentary procedure, the reasoning of the court is set out in a judgment written by myself. The argument is rejected on the basis that the court does not accept that the EU directive was intended to subject the operations of parliamentary democracy to the degree of judicial scrutiny suggested by the Advocates General. The Court of Justice has not endorsed their interpretation, but has repeatedly said that it is for national courts to determine whether the conditions which it has laid down have been satisfied. It cannot have been unaware of the importance of the separation of powers in European democracies and of the mutual respect which governs the relationship between the courts and the legislature, not only in this country, but elsewhere. And this court is not persuaded that it intended to override them. The court also notes that the contrary view would result in a conflict between EU law and the Bill of Rights of 1689, and it refers to a principle developed in German law that judgments of the European Court of Justice should be interpreted so as to avoid a conflict with national constitutional principles. The court does not in any event accept that parliamentary procedure is incompatible with EU law by reason of the influence of political parties and government policy upon voting. The legitimate role of political parties is recognized in EU law, in the Treaty on European Union, and in the EU Charter of Fundamental Rights, and it is part of the constitutional tradition of the UK and other member states. The influence of party policy or government policy does not prevent members of Parliament from giving responsible consideration to the matters that they have to decide, and the court sees no reason to doubt that when they come to make their decision on the HS2 bill, they will have adequate information available to them to allow them to consider the environmental implications of the proposal. Finally, Lord Neuberger and Lord Mance add a separate judgment considering the judgments of the Court of Justice in which the relevant directives have been interpreted.
Court is now adjourned.